Let's begin here. The Umkhonto weSizwe party's appeal against the Independent Electoral Commission's decision to uphold the objection against former President Jacob Zuma has been successful. The Electoral Court has dismissed the objection, and yesterday the specialist court heard arguments from the party as it challenged the IEC's disqualification of Zuma's candidacy based on Section 47, subsection 1E of the Constitution. Now, this section stipulates that any person convicted of an offence and sentenced to more than 12 months in prison without the option of a fine is ineligible to stand for public office. No order has been made on costs.
All right, now for more on this, we're joined by SABC News reporter Canny Maphanga, who has been following the case closely. Canny, so the former president can now stand as a candidate for the MK. We know that it was a simple order. Reasons are yet to be furnished. But one wonders, honestly, what could have persuaded, in the many arguments that Dalimpofu advanced, what could have persuaded the justices?
Well, good afternoon to you, Umkhonto, and to the viewers at home, rather. As the elections draw closer, we can expect that the former president in tomorrow's publishing of the candidate list will still appear on the number 1 of the Umkhonto weSizwe party list. Now, it's difficult to tell as to what informed the reasons behind the Electoral Court deciding to set aside that IEC decision of 28 March 2024 to uphold that objection. The objection has now been dismissed. However, in order to fully understand how the court arrived to this conclusion, we would need those full reasons to be furnished. And we understand that at a later stage, this will happen by the Electoral Court. But you saw the arguments yesterday that were advanced by the council, by the MK party, and that they first argued that the decision was irregular and not procedural because they didn't get notice from the IEC prior to that March 28 announcement. They also argued a lot on the question of a remission of sentence. They argued that this should have been taken into consideration before the IEC came to that conclusion, because you have to balance it with the safeguarding of those constitutional rights, those political rights that are afforded to all individuals. And it was Advocate Dalimpofu's assertion that the IEC rushed to reach to a conclusion without considering all the factors. It was his argument that the remission of sentence counts because it rather left the president with 3 months, instead of the 15 months that he had been given by the court. They, of course, advanced the issue of bias. They raised that one of the commissioners, Janet Love, had made a statement in public regarding the eligibility of the former president to stand. And that meant that Janet Love, according to the MK Council, had already decided on the matter or prematurely judged the issue prior to the objection being made to the IEC, which we saw the IEC upholding that objection, but that has since been set aside by the Electoral Court.
I want to take you to Section 47, subsection 1E, that many have spoken of. When Advocate Mpofu spoke about this particular section insofar as talking about where the IEC would derive its powers, he went on to say that in this instance they would have exceeded, they wouldn't have had the powers to implement this particular section of the Constitution. Can you just unpack that for us there when they were just going back and forth around the powers?
Sure. Section 47, subsection 1E governs the members of the National Assembly and who is disqualified from becoming a member of the National Assembly. Now, it clearly states that if you've been convicted of an offence and sentenced to 12 months or more without the option of a fine, then you're not eligible to stand for that candidature. Now, what the argument by the Council of MK Party was that the IEC exceeded its powers and its limitations in the Constitution by trying to decide on this issue, which they argue rests with the National Assembly itself. They've argued that the IEC's mandate is to ensure free and fair elections. So that is how elections are conducted, not who gets to stand and who gets to contest those elections.
And then I just want to take you a bit back to one very interesting argument at the very beginning. It seemed as though the justices were not following Advocate Mpofu's argument, because at one point he talked about Section 35 and said that when we talk about a free and fair trial, he does not believe that the former president's Section 35 rights were observed, and therefore he felt that he would not be somebody that would fall within Section 47, subsection 1E. And there was just a lot of back and forth where they were asking, are you looking to re-argue that which was determined in the Con Court?
Yes, there was that question regarding the question of whether there was an offence that was committed. There was a lot of back and forth about what the contempt of court conviction meant with respect to the former president, because it was a finding that was made in the Constitutional Court in part civil, some may argue part criminal proceedings, not in a trial or in a criminal proceeding where you see a person get charged, they appear before a judge, they get those constitutional rights to a fair trial, and a decision is made. And then, of course, you also have the option of an appeal. Now, we know in that instance, it just wasn't possible, and that decision is what it is. I mean, it can't be changed. So that was the back and forth, but I'm sure this is a question that's going to be answered by the judges when they give those reasons out in the judgment, which we expect to follow after this order, which basically confirms, if you look at the tight deadline of the IEC, at least tomorrow, we'll see that final candidate list, which we expect the former president to be on. It is my understanding that once that timetable by the IEC is set and it's gazetted, that you can't really work your way around it. You can't deviate from what has been set in that timetable. So while there is an option for an appeal, at least on the part of the IEC at the Constitutional Court, they will have to confirm if this is the case or not after receiving this order. But I don't know what the practical effect of that would be if the timetable is already set, that we are heading to elections in May, and the deadline for the candidate list to be published is tomorrow. So I'm not sure what the practical effect of such an option would be when we've seen the Electoral Court give out this order quite speedily because of this election timetable and the deadline that they have, the IEC rather, to publish those candidate lists.
It will be quite interesting to hear their response or reaction to today's orders. Canny, thank you very much for your time this afternoon. That's SABC reporter Canny Maphanga speaking to us.